Hi everyone, my name is Shazia Khan and today's session we're doing is Equity and Trust, and the learning outcome we're doing today is learning outcome 2, which is to understand the concept of the beneficiary principle and exceptions. Firstly, we'll look at just a summary of what we did in the last learning outcome, which is learning outcome 2, which was to understand the requirements for the creation of a valid trust. We looked at, in regards to that, what a trust is and why it exists and when it exists as well. We also looked at different types of trust, which is a fixed trust, discretionary trust, and what each trust identified. We looked at what are powers in a trust. So, to have mere power, which is where not only does the holder have discretion over his actions, he has discretion over whether to act in the first place. We then went on to look at ordinary powers. And then we went on to look at, in learning outcome 2, two forms of mere power, the fiduciary power and the non-fiduciary power. So fiduciary power is a trustee or some other person acting in a fiduciary capacity, which is granted a mere power. Fiduciary powers are powers in a different sense. So they're not part of the trust, but are pure power, something that can be done but does not need to be done, something valid but enforceable. We then went on to look at non-fiduciary powers. It's given to any person in their capacity when they're not acting as a fiduciary. We looked at the distinction between both of them. We then went on to 2.1 in learning outcome 2 and looked at analysing the features of different types of trusts and the importance of this. So we looked at discretionary trusts, ordinary trusts, fixed trust, and what they refer to and why they're so important. And in regards to a fixed trust, it could be for a fixed number of identified beneficiaries. So it depends on who the beneficiary is. We gave an example of a fixed trust as well. So if someone shall distribute all of their money to any of the grandchildren who enrolled onto a uni degree, and looked at the issue of discretion and beneficiaries. We then went on to look at cases in regards to that, such as the case of Saunders and Vautier. We then looked at discretionary trusts, and also we looked at 2.2, which looked at statutory rules and their case law interpretations in appropriate scenarios. And we looked at what the meaning of statutory rules is within an Act of Parliament, and where there are three actual rules that help courts in interpreting an Act of Parliament. And we looked at the three rules, which was literal, the golden and mischief rule. So the literal rule takes precedence, as we mentioned, over the others, and states the words in the statute must be interpreted to mean exactly what they say, however absurd or unfair the conclusion is. So it's what the wording of the statute says is a literal meaning of it. We looked at the example of a literal interpretation in the case of R and Harris, 1836. We then went on to look at the golden rule, which is a shadow of the literal rule, and should be used as backup where there's any sort of absurdities. We then went on to the mischief rule which attempts to the legislator to interpret a statute that's been passed, remedies, so like a loophole. The courts use the rule to decide what loophole, and the famous case in regards to the mischief rule is the case of Hayden's 1958, and where the courts will consider the elements of the four principles, which is what was the common law before the rule was passed, what solution was offered by Parliament, what is the true reason for the solution, and finally, what was the mischief the law did not solve. We then went on to look at several types of trusts, fixed trust, discretionary trust, express trust, and we looked at express trust with the element of 3 certainties: certainty of intention, certainty of subject matter, and certainty of objects. We then went on to look at certainty of intention in more detail and what it actually identified. And then we looked at a quite famous case in regards to this was the case of Re Gulbert Benkian, 1970, which looked at the issue of expressed intentions. And then also another famous case in regards to this was the case of Jones and Locke, 1865. We then went on to look at certainty of subject matter and referred to the case of Palmer and Simmons, 1854, which looked at not sufficient to constitute a certain matter. Then we went on to look at the case of Re London Wine Corporation, Shippers Limited, 1986. And we also went on to look at certainty of subject matters, of objects, sorry. Then we went on to look at 2.3, which was to analyse the impact of illegality on legal presumptions, looked at illegality of a contract, so whether the contract is illegal or not, and types of illegality as well. We looked at statutory prohibition of contracts in regards to express prohibitions and referred to the case of Re Mahmood and Isfani, 1921. We looked at implied prohibitions as well. We went on to look at common law prohibition of contracts or public policy, looked at public policy and used examples such as contracts to commit crimes, as in the case of Beresford and Royal Insurance Company Limited, 1938, and Biggers and Boosted, 1951. We also looked at contracts which prevent the administration of justice. Famous case in regards to that is the case of Hyman and Hyman, 1929. We also looked at contracts which are sexually immoral and in regards to contracts, Pierce and Brooks, 1865, and the case of Sutton and Michon de Ria, 2003. We went on to look at common law prohibition of contracts, so restraint of trade. And we looked at the case of Nordenfelt, Maxim Nordenfelt Guns and Ammunition Company Limited, 1894. We also looked at quite a famous case, is the contract reasonable in the case of Herbert Morris and Saxelby, 1916. We looked at the effect of illegality in the case of Holman and Johnson, 1775, and looked at Sadler and Imperial Life Insurance Company of Canada, 1988. We looked at collateral contracts in regard to Fisher and Bridges and how that can have an effect of protecting an innocent party to a promise or misrepresentation has been made. Claims based on illegal contract, the case of Eurodame and Bathurst, 1990. We also looked at recovery under illegal contracts under Learning Outcome 2 and looked at the case of Holman and Johnson and Shanshal Al-Kashtania. We looked at also where one party unfairly induced into illegal contracts as the result of duress or undue influence, and the case of Hughes and Liverpool Victoria Legal Friendly Society, Tribe and Tribe, and the case of Crayley and Thompson and Biggers and Boosted again, so where the contract was voluntarily withdrawn. So that was in regards to all that was in regards to Learning Outcome 2. Now we're moving on to Learning Outcome 3, which is to understand the concept of beneficiary principle and exceptions. So the indicative content, looking at understanding the concept and application of the beneficiary concept, the need for human beneficiary, the rule is in Saunders and Vautier, trusts of imperfect obligations, so purpose trusts recognize animals, monuments, tombs, fox hunting, private masses, judicial constructions in Re Denley's, gifts to unincorporated, various theories how such gifts are included in contractual theory. Assessment criteria. So 3.1, to examine the need for human beneficiary in private express trust. 3.2, to illustrate established exceptions to the beneficiary principle. 3.3, to describe the various methods by which gifts to be incorporated, associations may be effected. M3.1, explain various constructions of the application of beneficiary principle. And D3.1, evaluate socio-legal and political reasons for the policy choice to adhere to the beneficiary principle. So we've got different types of trusts. That's the first thing we need to look at, what the different types of trusts are. We've got types of express trusts. Express trust, charitable trust, private family trust, bare trust, fixed interest trust, assets in incorporated associations, unit and investment trust, trading trust, secret floating trust, protective trust, which comes from bare trusts, and discretionary trusts. So express trusts are a device of disposition which in land creates a purely nominal legal title that vests in the person named by the testor as the trustee. The title is purely nominal in that the property vested in them is not for their benefit, but instead for the benefit of another, namely the beneficiary. These trusts of trusteeships are made explicitly in the testamentary disposition of land in question, and so the trustee must act according to those terms. A breach of those terms is regarded as an affront to the conscience of the court of equity, and therefore a trustee can be required by court to comply with the express terms of the trust. So now we're moving on to charitable trusts. So exceptions to the beneficiary principle are things like charitable trusts, trusts of imperfect obligation, trusts which are for purposes but still have ascertainable beneficiaries, and some offshore trusts. Unincorporated associations as well are part of exceptions of the beneficiary principle. So a private trust. A private trust is an expression declaration by the person who wants to create trust during his lifetime. So a trust deed, a will, or other form of written or verbal. A private trust is not charitable, as we mentioned. The trust is said to be express trust when the settlor intentionally created it. So the settlor is the person creating the trust, and it's during the lifetime of the settlor. So the rule against perpetuity is also known as the rule against remoteness of vesting, requires that the future trust interests must be certain to vest with a defined period of time as a perpetuity period. For example, Catherine creates a trust to pay income to her husband, Colin, for life, then to hold the capital for her son Charles if he survives Colin. Charles' contingent interest must be certain to vest with the perpetuity period that applies to the trust. If it is not certain to do so, it is void at common law. Interests that are void at common law may be saved by provisions of the Perpetuities and Accumulations Act 2009, the Perpetuities and Accumulations Act 1964, or the Law of Property Act 1925. The Perpetuities and Accumulations Act 2009 also restricted the scope of the rule with effect from 6th of April 2010. For more information on the practice notes on perpetuities and trust, there's a link to go onto there for Accumulations 2009, which looks at the changes to the rule, and it's at the end, the link. So the beneficiary principle is a concept that a private express trust must be for the benefit of the beneficiary, who the trustee can either ascertain or who is at least ascertainable. The beneficiary principle is a policy of English trust law and trust Commonwealth jurisdiction that trusts which do not have charitable objects as under the UK Charities Act 2006, Section 2 and 3, and also do not make the trust property available for the benefit of defined property are void. The beneficiary principle requires that there be some person in whose favour the court is able to exercise the trust, and if there is no beneficiary, then the trust is not valid, as we just mentioned. So in practical terms, this means that settler must have the benefit of an individual or individuals. This requirement can be contrasted with the trust being set up to pursue a purpose. So English law traditionally frowns upon trust being for the benefit of the purpose. So as a general rule, a trust set up for a purpose instead of ascertained as ascertainable beneficiaries will be void. The principles are illustrated in the case of our re-ATHE settlement. The principle gives rise to the following questions. So what is a beneficiary? And so does the beneficiary principle demand? Is it true that a trust is valid only if it has a beneficiary? And should a trust be valid only if it has a beneficiary? Viscount Aston, so this is the case of Viscount Astor purported to declare a trust in February 1945 of most of the issued shares in the Observer Limited, a company owning a national newspaper. The trust provided that the shares were to be held for a number of purposes, including, for instance, the establishment, maintenance, and improvement of good understanding, sympathy, and cooperation between nations, and the preservation of the independence and integrity of newspapers. Crucially, the trust was only established for purposes, and it was not possible to say that any human beneficiary would directly benefit from the trust. Roxburgh Justice. Roxburgh held that the trust was void since there was no human beneficiary who could benefit from the trust. He relied on the earlier leading case of the Bowman and Secular Society Limited, in which Lord Parker had said a trust is to be valid must have the benefit of individuals, or must be, in that case, gifts for the benefit of the public, which the courts in this country recognise as charitable in the legal as opposed to popular sense of that term. Lord Justice Roxburgh examined the reasoning behind Lord Parker's statement. He pointed out at the heart of the trust was a series of equitable rights that a beneficiary enjoyed. These equitable rights had been hammered out in litigated cases over time. Taken as a whole, the people who enjoyed the equitable rights under trust, the beneficiaries, had the ability to enforce them against the trustees if the trustees refused to honour these rights voluntarily. In the case of Bowman and Secular Society Limited 1917, it concerned the issue of whether the certificate of incorporation is conclusive as to the existence and validity of a company. The case actually involved the registration of a company limited by the guarantee with the purpose that was challenged as contrary to public policy. A company limited by guarantee was formed on the purpose of advancing the idea that human welfare is the proper end of all thought and action. An argument was raised that the company's registration was improper because its purpose, which involved the denial of Christianity, was contrary to public policy and interest. The central legal issue in this case was whether the certificate of incorporation, once issued, conclusively determines the existence and validity of a company, even if its purposes are later challenged as unlawful or against public policy. The argument against the company's registration based on its purposes was rejected, and the company was deemed lawful. However, the House of Lords proceeded to consider the hypothetical situation where the registrar had registered a company with unlawful purposes. In that context, it was held that once the certificate of incorporation is issued, there's little that can be done to attack it. The case establishes the conclusive nature of certificate of incorporation concerning the existence and validity of a company. Even if the purpose of the company are later challenged as unlawful or against public policy, the certificate remains conclusive. This principle ensures certainty and finality in the process of company registration, emphasizing the importance of a certificate as a legal document. So an example that we've given in here, suppose Scott settles £100,000 on trust. He appoints Thomas as his trustee. Scott provides in the declaration of the trust that he wants the money to be invested by Thomas, and it proceeds to be used each year for the development of world peace. No doubt this is worthwhile purpose, but such a twist would be void since it infringes the beneficiary principle. Suppose Thomas refused to invest their money according to Scott's wishes. Who would then enforce the trust against him? There's no one to do so because there's no human beneficiary who could go to court and who could take a court action against him. Remember that as a settler, Scott cannot take action against the trustee for breach of trust because the settler, unless he has expressly reserved such a power to himself in the trust documentation, has no involvement in the trust once it has been established. So the rationale for the beneficiary principle. So the main reason behind the requirement that a trust should have a human beneficiary benefiting from it has been shown in the examination of the judgment in Roxburgh J. in Re Astor's Settlement Trust. His view echoing that of Lord Parker in Barlow and Secure Society Limited, which we just went through, reaffirmed the established position in Morris and Bishop of Durham that as far as trust was concerned, there must be somebody in whose favour the court can decree a performance. In the case, the key points in the case of Morris and Bishop Durham was that the case laid down the beneficiary principle, which states that a valid trust must be enforceable by definite objectives, with the exception of charitable trust. It also laid down that where a trust does not have a definite object, the trust property is held on resultant trust for the settler. In this case, there was a bequest to the Bishop of Durham upon trust for such objects of benevolence and liberality as the Bishop of Durham in his own discretion shall most approve of. It was held that the purported trust was not a charitable trust and did not arise as there was no ascertainable beneficiaries. And in the High Court of Chancery, the appeal was dismissed. The ruling of the Court of Chancery was upheld, and it was maxim, the execution of the trust shall be under the control of the court. It must be such a nature that it can be under the control so that the administration or can be reviewed by the court. If the trustee dies, the court itself can execute the trust. A trust, therefore, which in case of maladministration could be reformed and a due administration directed. In this sense, equity is acting in a mixture of both pragmatism and pre-planning. Equity realizes that not all trustees may act in the best interests of the beneficiary, but they may instead act to benefit themselves. For example, some trustees may simply fail in their obligation towards the trust by, for example, failing to take proper advice before investing trust money. If the trustees fail in their duties towards the trust, regardless of whether the trustees themselves benefit personally from their failings, there has to be someone who can take action against them. That person cannot be the settler, for, as we have seen, the settler generally steps out of the trust once he has set it up. By almost a process of elimination, the only person left in the relationship to ensure that the trustees keep the right track is the beneficiary. There is no one else to take action against the trustee. For example, the court will not of his own instigation take action, neither is there an office of government whose job is to hold the trustees of private trusts accountable. So it's quite a mixture of pre-planning, but it's quite hard to identify. English law therefore embodies the idea that there must be someone who can take action against the trustees into one of the ingredients required to declare trust, and that's the beneficiary principle. I think that's really important because they need someone there who's obviously a human being to identify this in regards to that. There's a second reason for the law of trust embodying the beneficiary principle is more of a legalistic reason. You saw how the concept of trust involves split ownership, then the trustees holds the title to the property and the beneficiary enjoys the equitable interest. An equitable interest will therefore always exist in a trust. There must be someone who can enjoy that equitable interest, as it cannot exist without it attaching to a beneficiary. And an equitable interest cannot simply float around without being owned, because of course equity abhors to a vacuum. The beneficiary principle therefore ensures that someone owns the equitable interest in the property of the trust. It's possible to see this second reason as being tied to the same underlying principle as certainty of object was considered at the heart, but concepts require beneficiary to be present, so there must be a beneficiary. So the beneficiary principle is really important in regards to trustees and beneficiaries. An incorporated association is not a legal person and cannot own property or be the beneficiary of a trust. A gift to an unincorporated association therefore may be treated as attempted trust for the purpose of association. And the case example in regards to that is a case of Leahy and Attorney General for NSW 1959. And this case suggests that there are only two mechanisms by which transfers can be made to unincorporated associations: purpose trust or joint tenancy. In this case, the tester left his property to be held on trust for an order of nuns with the following provisions. Firstly, clause 3, as to my property, known as Elmsley, upon trust for such order of the nuns of the Catholic Church or the Christian brothers as my executors and trustees shall select. Clause 5, he put in, the residue of his estate is to be put on trust. The money resulting from the sale shall be used to build a new convent or to alter existing convents. The receipt of the Reverend Mother of that particular order of nuns or convents shall be sufficient discharge. Section 37D of the Conveyances Act 1919 in New South Wales states, no trust shall be held invalid by reason that some non-charitable and invalid purposes, as well as some charitable purpose, is or could be deemed to be included in any of the purposes, or for which an application of the trust funds or any part thereof is by such trust directed or allowed. And then trustees filed to determine the validity of gifts under clauses 3 and 5. It was held that in the Privy Council, both gifts are valid by virtue of Section 37D Conveyancing Act 1919, New South Wales. If not for Section 37D, a gift to such charitable or other purposes as the trustees might think fit would be void. Another important case in regards to this is the commentary in the case of Neville Estates and Madden 1962, and it set out that there are 3 categories of transfer to incorporated associations. Joint tenancy, which is a gift to existing members as joint tenants. Their share is severed once they leave. Contract holding theory, which is a gift to members subject to contractual restriction. It cannot be severed by leaving the association. The gift actually remains vested in the current members of the body at the time. And thirdly, which was identified from the case of Neville Estates, is the trust. So the gift is held on trust. The gift will fail unless the unincorporated association is a charitable body. In the absence of words that impose a trust, a gift to unincorporated association is to accretion to funds which are subject matter of the contract between members. And that was identified in another really famous case of the famous case of Reacher, 1972. In the case of The Denley principle was one of the grounds on which Oliver J. upheld a gift on unincorporated association for the purposes of constructing buildings for its use. Oliver J.'s alternative ground was that the gift could be treated as an accretion of the association funds, which I mentioned earlier. Even if the approach is applied, the trust will still fail unless its duration limited to the perpetuity period at common law, generally 21 years. After Denley, the courts have adopted a benign approach to recognising purpose trusts as benefiting individuals directly. The Denley approach has been extended to gifts to unincorporated association. It has been applied to proceeds of the sale of land to be used as clubhouse, which was deemed to be the benefit of the club and its members. And it has even applied to cover a gift for the maintenance of private roads on a country estate for the benefit of its residents. Most controversially, the Denley rationale may be responsible for upholding quick close trusts. In this case, directors took a loan to pay a dividend, and this was paid into a discrete bank account. The company went into liquidation, and the House of Lords held that the lender had an equitable right to have the money used for the dividend payment. As this purpose could not be achieved, the funds returned to the lender on trust. The House of Lords subsequently suggested that the rationale behind the decision was that there was a factual beneficiary, for example, the lender, and therefore the trust was valid. However, it is noteworthy that this approach was received scathingly judicial criticism. What these cases show is that the courts take a more liberal approach to upholding the private purpose trust than has traditionally been in the case. The case remains that private purpose trusts in their purest sense, laying outside the exceptions created by the courts, will not be upheld. However, the courts have more adopted a benign approach to recognising certain trusts, can be seen as we mentioned earlier. More conservative views that these exceptions recognised only in very limited circumstances have eroded. Therefore, it cannot be said that English law does not recognise trust for purpose. So in the case of Grendel and Dresden, a residents' association incorporated for the purpose of maintaining private roads on an estate was upheld as invalid. Read Denley Trust for a definable class of purpose. So Denley was mentioned in that case as well. Alternatively, the gift may be construed as a trust for the present and future members. Such a trust would be valid since it would have human beneficiaries. This construction is unlikely, however, the intention to benefit present and future members is expressed. Furthermore, the trust must be restricted to present members and those joining within 125 years. Finally, the gift may be construed as this was analysed in the case of Eurecha, which we just mentioned. And then, although it's not the preferred approach in the absence of the words clearly demonstrating intention to impose a trust, as in the case of Hanchett Stamford and Attorney General, where membership dwindles to one and the remaining member was solely entitled to the association's property under the contract holding. So the facts in this case, the Performing and Captive Animals Defence League membership dwindled to one husband and wife. When the husband died, there was a substantial amount of assets, including a property worth £675,000 and stocks and shares worth 1.7 million. It was held in the High Court that the assets belonged to the remaining member, and in this case, it was the wife. The automatic dissolution happened when the membership of an unincorporated association falls to one. It ceases to exist, like Lord Justice Lewinson said. A member's rights are based on the contract, and contract must cease to bind once there's no one or no other party can enforce that. The remaining of the property belongs to the last remaining member, and in this case was the wife. As with other constructions already discussed, the contractual analysis guarantees that the settler's intention will be affected. In fact, this analysis can only ever be used where the members have sufficient control so that they can choose to use the funds for different purposes. or even to wind up the association and divide the funds between them. Only this will prevent infringement of the rule against perpetuities, which require that the gift must not tied up indefinitely. In the case of re-grant in 1980, a gift to a branch of Labour Party failed because its rules required property dealings and the rule alterations to be approved by the main Labour Party's National Executive Committee. This external control of the branch's asset meant that the contractual analysis could not be used. In Re Holy Town Football Club 2006, however, the contractual approach was applied despite the fact that outsiders had some limited control over the club's resolutions. In conclusion, it's not possible to ensure that a gift can continue to be used for the purposes of an incorporated association, except where these purposes are charitable. Trust of imperfect obligation. A trust of imperfect obligation, also known as a discretionary trust, is a type of trust arrangement where the trustee has the discretion to determine how the trust assets will be distributed among the beneficiaries. Unlike trusts with fixed or specific obligations where the beneficiaries have a legally enforceable right to the trust, a trust of imperfect obligation grants the trustee flexibility in determining when and how distribution will be made. This discretion allows trustees to consider various factors, such as the needs, circumstances, and welfare of the beneficiaries when making distribution decisions. Trusts of imperfect obligation are commonly used to provide for beneficiaries whose needs of circumstances may change over time, allowing trustees to adapt to evolving circumstances and ensure that trusts' assets are used more effectively for the benefit of the beneficiaries. A trust deemed valid but whose obligation the courts could not compel the trustees to carry out, hence the obligation of this trust are imperfect. Normally, a trust that creates an obligation on the trustees beyond the duty to benefit any ascertainable objects will be held invalid unless it is a charitable trust. The term trust of imperfect obligation is not a precise one, and different authors have used it to describe one or both of the following types of trust. Firstly, a trust possessing ascertainable human beneficiaries, but with supervening purposes, and the example of this is the case of Re Osaba 1979, where the trustees were directed to apply the fund towards the university education of the settler's daughter. The court interpreted this trust as for the benefit of the daughter, albeit with the supervening purpose of providing for her education. Second one is an anomalous valid trust, which we mentioned, such as the one described in the case of Re Endicott, 1960, whose designated purpose was for the maintenance of a grave. The difference between these two categories is that the Osaba trust specified a human beneficiary, whereas the Endicott trust did not. Consequently, the first category may not represent a strong exception to the beneficiary principle, while the second category certainly does. A trust of form described as in Ruth Denley's case, which we mentioned earlier, would probably not be described as trust of imperfect obligation, since the court found it possible to construe the trust as allowing for human beneficiaries who could properly enforce it. Such trusts fall into three categories: trusts relating to tombs and monuments, trust for the provision of masses in private, and trust benefiting a specific animal. The purposes trusts are which still, however, need to meet their other requirements to form a valid express trust. So they must comply with any requirement or formality, adhere to the principles of certainty and the rules against perpetuity. So trust relating to tombs and monuments. So purpose trusts can also be valid if they're the erection of maintenance of tombs and memorials, assuming some memorials are not overly grandiose, the maintenance of animals, and arguably the saying of masses, although these must all obey the rule against perpetuaries and not continue for more than 21 years after. So these types of trusts arise where property is left on trust with the purpose of providing for the establishment. In Harry Hooper left £1,000 on trust for trustees to invest and use the income for 4 purposes. Okay, so firstly, the upkeep of his parents' grave in Torquay Cemetery. Secondly, the upkeep of a vault and monument also in Torquay Cemetery, in which his wife and daughter were buried. Thirdly, the upkeep of a grave and monument in a churchyard near Ipswich, in which his son was buried, and the care of tablet and a window in a church at Aylsham, which were devoted to the memories of some of his family members. The issue for the High Court was whether the trust was valid. Clearly, there could be no defined human beneficiaries of the trust, as all the people to whom the trust referred had already predeceased Mr. Hooper. Justice Morgan held that the trust overall was valid. In a short judgment, the reasoning why the trust was valid was not especially detailed. He followed an earlier High Court decision which had reached the same result, and Justice Morgan was guided by matters of pragmatism. What is a discretionary trust? So a discretionary trust gives trustees the power to decide how much beneficiaries get from a trust and when they get it. Like, all capital and income is distributed and completely at their discretion. So this means more flexibility, and assets can be protected if circumstances change for any reason. It's best to write a letter of guidance for the trustees to help them make the decision in accordance to your wishes. So you can choose anyone to be the beneficiary. They might be named individuals, classes of people. So maybe your grandchildren, your descendants, a charity, a number of charities, or organizations. Discretionary trusts, by their very nature, place a lot of power in the hands of the trustees. For this reason, it's important to make sure that at least one person in charge who doesn't have a financial interest in the trust. Role of the discretionary trust is to protect trust property and adaptability. Discretionary trusts are often used as an important part of estate planning. They can vary tax efficient, assisted with inheritance planning, or used for specific purposes, such as the lifetime provision of income for a child with severe disabilities. So, it's really important that they are there to, protect the assets of the beneficiary. And in regards to that, they have the power to protect the trust property. It's really important you look at, it prevents like safeguard to the trust fund from any sort of beneficiaries that are inexperience. Trusts and the tests. So when we look at trusts and the test, we look at this trust of certainty of objects. So you need to determine the object with certainty. Failure to do this will breach of the trust, and there's 2 trust criterion certainty test and the in and out test. So there's certainty of objects if the beneficiaries are ascertainable. In a fixed trust, there's a certainty of objects. If it is possible to produce a complete list of beneficiaries. In a discretionary trust, the individual ascertainable test to determine the certainty of objects. So certainty of objects, when we looked at, is where the trust has more than one beneficiary, but the settler has not identified each and every beneficiary, but refers to them instead of as classes, like maybe for grandchildren or for employees. So, examples could be things like, it might be my employee, it might be for my charity. It's really important when you look at certainty of trust. In a fixed trust, each beneficiary is entitled to a specific share of the trust. So it's important in regards to looking at that when you're looking at certainty of objects. So the case of MacPhail and Dalton, really important case in 1917. I'll go through the case with you and what happened in regards to that. In the case of MacPhail and Dalton, in order to allocate property according to the testator's wishes, equity recognises both that a trustee and a power of appointment. So the donee of such power will distribute the property by making appointments to the subjects of the power. However, a donee is not under an obligation to exercise his power, and he has absolute discretion to assign the property. By contrast, a trustee is under obligation to distribute the property to the objects of the trust, who can then enforce that obligation should the trustee fail to do so. In MacPhail, Bertram Burden, it established a fund for the benefit of the staff of Matthew Hall and Company Limited. He died in 1960, and the executors of the trust claimed that the trust was invalid for uncertainty of objects. It was therefore a power, not a trust. The issue contested was contained in Clause 9, subsection A of the trust deed, which said that the trustees shall apply the net income of the funding in making at their absolute discretion to or for the benefit of any of the officers and employees of ex-officers or ex-employees of the company, or to any relatives or dependents of such persons, which are the trustees shall be under no obligation to see the application of the money. On appeal, the Court of Appeal ruled that 1. Clause 9, subsection A constituted a trust because the word shall combined with the power of selection created a trust for the distribution of income. Secondly, that the test for certainty of objects was similar to that applied to powers. If it can be said with certainty that any given person or not a member of the class, the trust will not fail only because it's impossible to ascertain every member of the class. Through this decision, MacPhail constitutes a turning point because it changed the certainty requirements for the discretionary trust. After MacPhail, in a discretionary trust, the trustees has the discretion to appoint within a class of potential objects, and the trust will fail only if the definition of the class is conceptually uncertain. Providing the meaning of the words in the trust are sufficiently clear, so it can be said of any given person, whether they would be or not a member of the class, it does not matter. If every potential member cannot be identified by evidence, the test for ascertaining if a person falls within the class is applied generically rather than to a particular person. Therefore, the trustee only has to make a survey of the class and then select the beneficiaries from that class, which is the same rule that applies to fiduciary powers of appointment, which was established in the earlier case, which we mentioned, Regal Bienick. In other words, the trustee must find the permissible area of selection, but does not mean that he has to identify every single member of that class of objects before making any allocations. MacPhail is a good example of non-executive, exhaustive discretionary trust, where the trustees have the power to distribute the fund, but also to accumulate it. In contrast, a fixed trust is one in which the shares and proportions are determined by the settlor when he created the fund. Therefore, it will be void for uncertainty unless it is possible to draw up a complete list of each person who is a member of the class. Previous to the case of MacPhail, this was also the test applied to his discretionary trust, but the complete list test was unworkable for the trusts such as the MacPhail because it would be impossible to draw up a complete list. The court were aware that this concept could limit the social function of discretionary trust cases. Pre-MacPhail case, also place too much weight on the distinction between trusts and powers of appointment. Instead, MacPhail established that all that was required was that it could be said with certainty if a given person or is not a member of a class. So it identified the importance of identifying that, you know, that the trust, the certainty of object trust is important to apply. So here's some links that you could use for the further reading. So if there's any sort of further reading you want to go into, there's a link here which is on trust formation, and it looks at the beneficiary principle in more detail. Also, there's additional reading for you to go on to if you want on Moodle, and any ebooks on Moodle that you need to refer to. We finished learning outcome 3 now on equity and trust unit, and these are some of the links that I've got down here. Ebooks again on Moodle, some of the links on NetLaw, MAN, Law Explores, Halilus, and Law Teacher that you could actually refer to if you just want to get basic concepts or look at the case law around it. There are links on Moodle in regards to that additional reading. Again, if you have any questions, now that we've finished learning outcome 3, the next learning outcome is learning outcome 4, then assignment discussion. If you have any questions around learning outcome 1, 2, or 3, which we've done up to date now, please email learnerwork@ukvarsity.co.uk. If you have any questions around the resources or any recordings that we've done, they all will be available for you on Moodle that you can go on to, and any sort of extra reading that I've referred you to, for example, the article that you could go to and have a look around the beneficiary principle and the importance of the beneficiary principle and how it's applied in certain cases with reference to examples. You can go on there. Again, if you've got any questions, email learnerwork@ukvarsity.co.uk, and please refer to Moodle for your resources, and any questions, learnerwork@ukvarsity.co.uk. So the next learning outcome is learning outcome 4, then assignment discussion, and thank you for attending today's session.